import the limited part when the wider is struck down?
No, limited was sustained, wider was struck down.
Wider was the wider goes.
But the brother is saying, how will it come back on its own?
That's why
You would like us.
it was sustained in Keshwanand Bharti. That's what Vaman Rao said.
Sustained in Keshanan, then section 4 of the 42nd amendment substituted it completely.
Can your lordship,
Substituted section 4 was struck down in Minerva.
if your lordship wish to go into it, we will go into it. Right? But kindly, my lord, allow me, there is a last 5 judgment
Now,
which
tell us-
squarely deals with this.
Show us if from Minerva, what is the operative order? What is struck down in Minerva? Let's just see Minerva.
Lord, can I show, my lord, this complete list?
Before that, just let's see what is struck down in Minerva.
Let it be taken up. My lord, I think, my lord,
No, we want Minerva. What is the operative part in Minerva? That's all. This shows that. It will just complete this process for us. That's all.
my lord,
And
if
if
your lordship
my-
see, my lord, that is there in page 7. That's what I'm saying.
Why don't you show us from
Well,
volume 5?
I'll show it, my lord. from there.
Volume 5.
In the meanwhile, if I may
Yes.
just point out one fact with my lord,
Point out-
Justice Bindus, no, not my argument.
Solicitors on his
Lodge,
right.
lodge.
Just tell us what is the page of the operative direction in Minerva?
2085.
Paragraph
2085.
Which volume is it?
Volume 5.
Volume 5, page 2085.
Yes. Para 70, my lord. 75, my lord, 75. Yes. Those then are our reasons for order, which we passed on 9th May, as my lord the Chief Justice was, to the following effect. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abrases any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. So the entire directive principles of state policy.
Of the 42nd Amendment.
Would your lordships?
1-4. Where did you get that page? 2066.
There are 14.
May I assist your lordship and the learned solicitor general? Lord, the direct observation is para 58.
If you don't mind, Zal, I'll just conclude.
Question never we specifies that.
2066. Correct.
But I left my note, my lord, at a very crucial juncture, my lord, if your
We'll come back
lordship
to it. No, no, we'll come back. to
would
it.
have seen the
This para
operative
14
part of Vaman Rao, my lord, would have assisted, your
We'll
lordship.
just look at this and then go to that.
Yes, my lord, para 14. Section 4 of 42nd Amendment, which was brought into force with effect from January 3, 1977, amended Article 31C of the Constitution by substituting the words and phrases all or any of the principles laid down in Part 4.
That is
for-
that's a little bit of a ticklish issue because it substitutes all or any of the principles.
Well, that is considered, that issue is, well, that issue is considered by a five-judge bench.
All right. Now
That's
we'll
not
go
what
back-
I want your lordships
We'll
to
go
see.
back to your note, yes.
Yes, Lord. Lord, page 7, page 8, page 8. Lord, PDF page 8, Vaman Rao. E, Roman 2B, short note on behalf of SG, my lord, and it's page 8. Lord, this is the order of the court, my lord, this is quoted by me.
Two is, when you're opening a new,
We'll have to. I feel, my lord, your lordships.
I think the logistics about opening multiple windows, that's all. Nothing else.
No, no. My lord, order of the court, page 8, my lords.
Page,
Page 8, PDF 8, note, my lord, volume 2B,
page 8, para.
the order of the court.
Oh, order of the court. Yes, yes.
This is not my words, my lord, that's how it is recorded in the judgment. Article 31C of the Constitution, this five-judge bench in Vaman Rao. Article 31C of the Constitution, as it stood prior to its amendment by Section 4, there is a declaration, yes. And thereafter NGSC. After considering Minerva, Vaman Rao, my lord, the judgment says this. The Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of Constitution 42nd Amendment Act, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharati. The revival declaration. Lord, as my learned friend Mr. Shankar Narayan rightly says, that if a player is on the field, you send a substitute. Substitute goes, the player also doesn't go, but simultaneously. He remains. As it stood prior to so-and-so, Article 31C, as it stood prior to Constitution 42nd Amendment Act, does not damage any of the basic.
Now tell us, Mr. Solicitor, when a constitutional provision is amended by substituting a new provision in its place, does the original provision stand?
Yes, madam. That is what was again considered.
This is their entire argument, that it doesn't.
When a constitutional provision is substituted by a fresh provision, the fresh provision comes into force instead and in place of the original provision. Right? Now, if the validity of the fresh or the amended provision is struck down, on what theory of law does the original provision get revived? That's the point.
Would your lordship see, my lord, the NJSC judgment, again a five-judge bench, where this question is squarely raised.
Now, since you are on Vaman Rao, But remember, Mr. Nariman had argued that, well, Vamana Rao proceeded on a concession by Mr. Palkiwala. Where is that concession recorded in Vamana Rao? That's
Not in Vaman Rao, my lord,
That is-
that's in Minerva. my lord.
That assumption is where? In Minerva or in Vamana Rao?
Vaman.
That's Mr. Nariman's argument.
Mr. Ar-
In Minerva, in Minerva.
That's his argument. That's not what is held. But Mr. Nariman's argument is based on which part of the judgment?
Since
He said that Mr. Palkiwala conceded this position. Now, where does Mr. Nariman get that from?
there's no concession.
Probably that is in.
That is in
Sanjeev
Sanjeev
Coke,
Coke's
Sanjeev
property.
Coke.
That is probably in that case. When Minerva Mill has been discussed by Justice O. Chinnappa Reddy, and then there is something.
Now, NJSC, where do we get? Yeah, that's right.
Yes, my lord, kindly come to NJSC. NJSC squarely this, my lord, question which fell from my lord, the Chief Justice, my lord, was raised.
Check up somebody.
In the meanwhile, no, we'll do that.
Where is it?
Volume,
Yeah, it may be in.
volume. NJSC.
We are perplexed, something like that.
Huh?
We are perplexed.
Yeah, your lordship.
The judge says that,
See,
we are not saying it.
in Sanjeev Coke, they have said that bench was perplexed.
Perplexed by this.
Judgment in Minerva Mills,
Yes.
And then it comes.
not us.
Yeah, your lordship will never be perplexed. A page number? Please come to volume 5, NJSC judgment. This contention was raised. Lord, page 3877, my lord. Para 408. There is a title given in the judgment.
Mr. Solicitor, that argument of Mr. Nariman's, which is referred to in the first deferring order, was on the basis of Minerva. Because I'm now at volume 5, page 2790.
Correct.
Where he says they record Mr. Nariman's submission, volume 5, page 2790. He contended that the decision in Minerva Mills proceeded on the basis of a concession made by Mr. Palkiwala and on an assumption that Article 31C, as it survived as a result in Keshwan Bharti, stood revived after the subsequent events. That seems to have been his submission at that point.
Yes, my lord, your lordship are on page 2790, my lord.
790.
Para 5.
Para 5, Mr. Nariman's submission.
My lord, I would, my lord, speaking for myself, my lord, when Nani Palkiwala gives some concession, my lord, on the basis of Keshwanand Bharti, my lord, I would respectfully buy it, my lord. There must be a good reason not to. Yes, my friend, my lord, para, my lord, no, para, what's the first name? 2069. 2069, my lord. But possibly it's not concession. Para 24, my lord.
It's 5.
This is
This is Minerva Mills. Possibly, the paraphrasing by Mr. Nariman, my lord, appears to be a little inaccurate. It was not a concession.
Which was the para in Minerva page?
My lord, page number 2069, para 24. Does my lords get, my lord?
Yes.
The next question which we have to consider is whether the amendment made by section 4 of the 42nd amendment to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C, and indeed, that could not be done. The unamended 31C forms the subject matter of a separate proceedings, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshwanand Bharti. It was neither on assumption or concession. But possibly, Mr. Sirvai in his book writes, Lord, possibly, Mr. Sirvai in his book writes that this was a concession. Possibly, my lord, that's from where, my lord, Mr. Nariman, my lord, the learned counsel, Mr. Nariman. Yes, my lord. It's a statement of fact, my lord, not a concession. Now, my lord, may I come to, my lord, NJSC judgment?
NJSC, now where's NJSC?
3877, at 3877. Same volume, my lord. This is, my lord, majority view of my lord Justice Kehar. And on, my lord, similar view is taken by Justice Joseph also. Which is the para number? Let's see. $255, similar submission is raised, my lord. I'll just, my lord, come to that, but please see 5, the effect of striking down the impugned constitutional amendment. Does your lordships get, my lord? Would the amended provisions of the constitution revive if the impugned constitutional amendment was to be set aside as being violative of the basic structure of the constitution? It would be relevant to mention that the instant issue was not adverted to by the learned counsel for the petitioners, possibly on the assumption that if on consideration of present controversy, this court would strike down the Constitution 99th Amendment Act, then Article 124 so and so, as they existed prior to the impugned order, would revive. And on such revival, the judgment rendered in the second and third judges' case would again regulate selection and appointments, as also transfer of judges of the higher judiciary. A serious objection to the aforesaid assumption was raised on behalf of the respondents by the learned solicitor, by the Solicitor General, who contended that striking down of the impugned constitutional amendment would not result in the revival of provisions which had been amended by Parliament. My lord, contrary to what I am urging now was the argument that it doesn't revive. In order to canvass the aforesaid proposition, reliance was placed on Article 367, which postulates that provisions of the General Clauses Act had to be applied for an interpretation of the articles of the Constitution in the same manner as the provisions of the General Clauses Act are applicable for an interpretation of ordinary legislation. Insofar as the instant submission is concerned, we have no hesitation in affirming that unless the context requires otherwise, the provisions of the General Clauses Act would apply. Now kindly directly see 3886. But I'm sorry, my lord, my learned wants me to come to 3813 first.
38?
Based on, my lord, what? 3813, my lord. Para 255.1. These very proceedings were relied upon by, my lord, my worthy predecessor, the learned Solicitor General. Your lordship gets, my lord? This is the same judgment, NJSC. The contention is noted, my lord.
Property owners.
Yes, madam. Firstly, that the issue whether a constitutional amendment once struck down would revive the original substituted article was a matter which at 255.1, my lords, page 3813. But please see the last sentence, my lord, of this. After quoting, my lord, the judgments, Property Owners Association, my lord, all three Property Owners Association, respective references. It was submitted that the order passed by this court, am I with your lordship, my lord? Order passed by this court wherein the reference to a 9-judge constitution bench had been made was a case relating to constitutionality of Article 31C. It was pointed out that Article 31C as originally enacted provided that it was submitted that the later part of 31C, which provided and no law containing declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy has been struck down by this court in Keshwanand Bharti case. It was contended that when the matter pertaining to the effect of the striking down of a constitutional amendment had been referred to a 9-judge bench, it would be improper for this court, sitting in its present composition, to determine the aforesaid issue. So, my lord, the request was that on this issue, you kindly refer it to a larger 9-judge bench. And, my lord, now the answer, my lord, at page,
And then 255.2.
yes, I'm sorry, my lord.
This is a submission of the Solicitor General then.
Yes, my lord. The second contention advanced at the hands of the learned Solicitor General was based on section 6, 7 and 8 of the General Clauses Act. It was contended that an amendment which had deleted some part of the erstwhile Article 124 of the Constitution and substituted in its place something different, as in case of Article 124 of the Constitution Act, 99th Amendment Act, would not result in the revival of the original article which was in place prior to the constitutional amendment. Even if the 99th Amendment itself was to be struck down, it was submitted that if a substituted provision was declared as unconstitutional for whatever ground or reasons, the same would not automatically result in the revival of the repealed provision. In order to support the aforesaid contention, reliance was placed on so-and-so, 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 my lord. It was submitted the general rule of construction.
No, you go by this.
Now, please come to, my lord, page 3877.
Read actually. Yes, you-
Just, my lord, trying to point out, my lord, that there was a suggestion that in a combination of 5 honorable judges, revival question be not decided, because this reference, this particular present reference is referred to a 9-judge bench, and it does not stand revived. That was the contention. My lord, I have read para 408, 409 under the title Effect of Striking Down of the Impugned Constitutional Amendment. Now, please, my lord, directly come to page 3886.
7, page
3886. Lord, all the judgments, my lord, which the learned Solicitor General, my lord, the then Solicitor General, my lord, referred to and relied upon were discussed. And, my lord, after the quotation of the judgment, after classitum D, what needs to be noticed, does your lordship get, my lord? What needs to be noticed?
page 3886. 3886.
My lord, may I read? Your ladyship gets, my lord.
886.
3886, after the quotation of the judgment relied upon, just below classitum D. What needs to be noticed from the extract reproduced above is that this court, in the above judgment, clearly concluded that the legal effect on an earlier law, when the later law enacted in its place was declared invalid. May I continue, my lord, after that?
Yes, their argument. were reading NJSC.
Yes, my lord, I must say, my lord, sometimes we assist your lordships as officers of the court. And your lordships would find out why. My lord, the way, my lord, if we travel the path, my lord, which we are considering, your lordships are considering, what would be the consequence? Now, please bear in mind, Article 124 was in question in this judgment, which says that the president, in consultation with such judges as he thinks appropriate, will make appointment. There was a substitution by the word National Judicial Commission. And the argument made was on our behalf, the Solicitor General, that now that provision goes because you are declaring the provision to be unconstitutional. Please see, 3886. What needs to be noticed from the extract reproduced above is that this court in the above judgment clearly concluded that the legal effect of an earlier law, when the later law enacted in its place was declared invalid, did not depend merely upon the use of the words like substitution or supersession, and further, that it would depend on the totality of the circumstances and context in which the provision was couched. If the contention advanced by the learned Solicitor General is accepted, it would lead to a constitutional breakdown. The tremors of such situation are already being felt. The retiring judges of the higher judiciary are not being substituted by fresh appointments. The above judgment in our considered view does not support the submission being canvassed because on the consideration of, then my lord, the earlier judgments quotes are taken, totality of circumstances and the context. The instant contention is just not acceptable. We are therefore of the considered view that even the instant judgment cannot be of no avail to the respondent insofar as present controversy is concerned. Now, please come to 3888. This is, my lord, the majority view penned by my lord Justice Kehar, my lord. My lord, immediately after the quotation, what needs to be kept, my lord, your lordship says that. What needs to be kept in mind, as we have repeatedly expressed above, is that the issue canvassed in the judgments relied upon was the effect of a voluntary decision of a legislature in amending or repealing an existing provision. That position would arise if Parliament had validly amended or repealed an existing constitutional provision. Herein, the impugned constitutional amendment has definitely the effect of substituting some of the existing provisions of the Constitution and also adding to it some new provisions. Naturally, substitution connotes that the earlier provision ceases to exist and the amended provisions takes its place. The present situation is one where the impugned constitutional amendment by a process of judicial review has been set aside. Such being the position, whatever be the cause and effect of the impugned constitutional amendment, the same will be deemed to be set aside and the position preceding the amendment will be restored. It does not matter what are the stages or steps of the cause and effect of the amendment. All the stages and steps will stand negated in the same fashion as they were introduced by the amendment when the amended provisions are set aside. Then please.
Against what you are canvassing, because that there they say if it's a pure substitution, the earlier provision ceases to have effect. They said since the substituted provision was held to be unconstitutional by the Supreme Court, therefore the earlier provision is revived. But when there is a pure substitution, as in the case of 31C being substituted, the earlier provision ceases to have effect.
That is negative by them. May I read?
No.
May I read, my lord?
Yes. What needs to be kept in mind?
My lord, kindly a little above that, my lord.
B, placitum B.
B. What needs to be kept in mind, my lord, I have no difficulty, your lordships may go into, I am just, my lord, sounding an alarm. What will be the position, my lord? What will be the consequence of holding?
Consequence, we will see what is to be done if we are of the view that, well, the original 31C is not revived. What consequence we will of course have to
I'm not on 31C. 31C is also
consequence.
few words substituted. Few words are substituted in 31C. Here also, instead of consultation with as many judges, such judges.
They say that this was not a case of a pure substitution. but that a substituted provision was held to be unconstitutional by the Supreme Court. And therefore, they say it is unconstitutional on the date of its enactment, and therefore, the original provision continues to
That is
subsist.
the proposition in 31C as well.
No.
And I have nothing to say. Lord.
How?
What is the position, my lords? That is the position. Minerva Mill strikes down that substituted part.
Section 4, the entirety of Section 4 of the 42nd Amendment completely substitutes that provision.
Let us read section 4, section 4.
Lord, same NJSE. Well, I'll just point out, same is NJSE, my lord. My lord, I have no difficulty if your lordship takes the view, that the government would stand to benefit. I'm assisting your lordship as an officer of the court. In a, my lord, we can go into academic discussion. I'm just pointing out the catastrophic, my lord, the void which is created. What will be the impact of that void? That's what I am saying. My lord, suppose, give me allow.
There was no void, as in the case of NJSC. NJSC, what happened was,
I-
they said that there's a breakdown of constitutional machinery because there would be no mechanism left. This is only an immunity provision.
Lord, if that is the distinction your lordship draws, my lord, then, my lord, we are on whether,
The law does not become ipso facto invalid. It only loses its immunity from challenge under 14.
Lord, suppose, my lord, kindly, my lord, sounding an alert as an officer of the court. The parliament does not like a particular provision. It substitutes a part of it. Kindly, my lord, allow me, my lord, your lordship's attention for some time. There would be some more distinctions your lordship will be able to draw, my lord, from this, my lord. But allow me, my lord, a more, little, my lord, I'm sorry.
Yeah.
Parliament does not like the particular provision. It substitutes the way section 4 was, your lordships have seen, and I'll show NJSC my lord, the provision also, I have kept it ready. It substitutes a part of it, which is declared unconstitutional, and as the other side is contending, the entire provision does not revive. It goes. Correct, my lord? The parliament may not reenact the original provision. Yeah, the court can never issue a mandamus to the parliament to.
But that's the discretion of parliament. That ultimately.
My lord, please do that, my lord. I am happy with that, my lord. I am happy, my lord, even in this case. I'll show it's exactly identical. Section 4 of 31C was, my lord, NJSC. I'll show. That was precisely the argument.
Possibly, because what you are contending is that the substituted words by the 42nd Amendment was struck down by this court.
Correct, my lord. Therefore, therefore a declaration. In Vaman Rao, there was a declaration made that the position as prevailing prior to that amendment will now stand restored and revived. And no court has thereafter doubted that. I'm saying something against me, my lord. I'm not resisting that. As an officer of the court, my lord, I'm before a 9-judge bench. Possibly, therefore, after Vaman Rao, no 5-judge bench has, my lord, gone into 31C revival issue. Possibly, my lord. This is my assumption. Now, please see, my lord, further. Para 413. Even though we have already recorded our determination with reference to the judgment cited by the learned Solicitor General, it is imperative for us to record that it is evident from the conclusions returned in central provinces so-and-so, that in facts and circumstances of the present case, it would have to be kept in mind that if the construction suggested by the learned Solicitor General was to be adopted, it would result in the creation of a void. We say so because if neither the impugned constitutional provision nor the amended provision of the Constitution would survive, it would lead to breakdown of the constitutional machinery inasmuch as there would be a lacuna or a hiatus insofar as the manner of selection and appointment of judges to the higher judiciary is concerned. Such a position, in our view, cannot be the result of any sound process of interpretation. Likewise, from the observation emerging out of the decision rendered in Indian Express, we are satisfied that the clear intent of Parliament while enacting the Constitution 99th Amendment Act was to provide for a new process of selection and appointment of judges to the higher judiciary by amending the existing provisions. Naturally, therefore, when the amended provision postulating a different procedure is set aside, the original process of selection and appointment under the unamended provision would revive. The above position also emerges from the legal position declared in Koteshwar Vittal Kamat. It is not possible for us to accept the inferential contention advanced at the hands of the learned counsel for the respondents by placing reliance on section so-and-so of General Clauses Act. We say so because the contention of the learned Solicitor General was based on the assumption that a judicial verdict setting aside an amendment has the same effect as a repeal of an enactment through a legislation. This is an unacceptable assumption. When a legislature amends or repeals an existing provision, its action is its own free will and is premised on well-founded principles of interpretation, including the provisions of the General Clauses Act. Not so when an amendment / repeal is set aside through a judicial process. It is not necessary to repeat the consideration recorded in para so-and-so above. When a judgment set aside an amendment or repeal by the legislature, it is but natural that status quo ante would stand restored. But possibly your lordships may not like to draw the distinction between a provision which creates a void and a provision which does not create the void. Your lordship would decide the question of law, what would happen when there is declaration of unconstitutionality of a part of the provision, whether it is 31C, which possibly may not leave any void, and will leave a void. I'm on demurrer that it may not leave a void, and here it would leave a void. Now, please see, my lord, the other view, my lord, at page 4106. 41. I'm sorry, my lord, my friends, my lord, want me to. 415, my lord. 415, my lord. For the reasons recorded herein above, my lord, the same. The same page, my lord, page 3889. Same page which I was reading. For the reasons recorded herein above,
Yes, of-
permission is when an amendment which substitute few parts of a main provision is struck down. Without that part, the provision remains. That is, my lord, the position. And if your lordships, I'll show to
Question is, what part remains?
unamended part, my lord, which is not set aside.
The unamended part minus the substituted part may possibly remain. But in
Yes,
this case,
that's all we are saying.
but in this case, minus the substituted part, the original part has no meaning at all.
No, my lord, it has a meaning. Please take the chart, my lord.
Yes.
Please take the chart, my lord. Please take the chart, my lord. Lord, kindly see the.
Second last column. Take the second last column.
I'm taking that, my lord. Achha, the same with you,
or take the third last column actually. Post
It would
76
revert back, my lord, to what the Keshwanand Bharati, my lord,
No, 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 it doesn't. That's the point. Just see, I'll tell you why.
My lord, it's better, my lord, we will address your lordship on marriage. I was arguing against me. That please don't go into this, don't travel into this path. Because there are several judgments which have come relying upon, my lord, 131,
That
134.
It's not that clear. It's a very debatable issue. We have to decide the issue.
It's not therefore referred to your lordship.
See, sir, see the third last column. Okay, the third last column, 31C.
Yes, my lord.
Saving of laws giving effect to certain directive principles. Notwithstanding anything contained in 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by 14, 19 or 31. Right? After that it was struck down in Keshwanand. Now, if this part, all or any of the principles laid down in part 4 is obliterated because it is struck down, then how does,
This is not struck down, my lord.
of course, this is struck down in Minerva Mills.
No, my lord. Look, kindly see, but
All
just third,
principles laid down in
Third-
part 4 is struck down in Minerva
my
Mills.
lord, third column, please see third column. My lord. Section 4 of, my lord, post 76. The principles specified in clause B or clause C confusion because of the confusion which we have.
Para 58 of Minerva. Para 58 of Minerva Mills says, Para 58 of Minerva Mills, which is at page 2079 says,
I've also done
that by granting immunity on a challenge based on Article 14 and 19, on the ground that the directive principles are being subserved, they say every legislation virtually will be protected by that umbrella. So they strike it down on the ground of basic structure, saying that giving an immunity from 14 and 19 would violate the basic structure. That's the problem.
Allow me to clarify
Yes.
the confusion which is charged.
Functional utility of 14 and 19 goes. then.
Take the chart for a second.
Yes.
Take the chart. And it comes in the third chart,
The third column.
the third column, whichever being. Uh, This is my.
Right.
The principal specified clause C. Or way of. Come, we part.
All right, now just let's wait here for a second. The words, the principles specified in clause B or clause C of Article 39 is subsumed in the expression all or any of the principles laid down in part 4.
Substituted.
Subsumed, it is subsumed.
Part of
The word used is anyway, subsumed. Yes.
Substituted is a legislative device, but subsumed means the larger includes the smaller. So if the earlier words are subsumed in what is substituted, then when the entirety of what is substituted is struck down, that will not result in the revival of what is the original provision. That's the problem.
Only a minute.
And if you read this now in the context of para 58 of Minerva, they say that granting this immunity on the grounds of 14 and 19 itself violates the basic features of the Constitution. That's the problem.
Lord, kindly, Lord, I wanted to,
See, NJSC, I'll tell you one thing. NJSC, they realize that there is a problem. Namely, that when you strike down, that's why the Solicitor General was arguing, your counterpart was arguing that, look, if you strike down the NJSC amendment, that will not result in revival. That's why what did the court throw in the exercise of its 142 power? They said, one second.
not 142, the court interprets. Court interprets.
What did the court say? The court said that this will lead to a constitutional breakdown. We are not in a situation of constitutional breakdown. Why? Because if 31C is no longer there, all that it means that any law has to meet the standard of 14 and 19. If no law is invalidated ipso facto.
Lord, that would be a,
Not to be tested, that's all.
Lord,
There is no constitutional breakdown.
that would be
Immunity is
distinction
lifted,
without a
that's all.
difference, my lord, only
The
to.
law is lifted.
I'm sure your lordships would not try to come out of NJSC finding on 142. It was a finding.
All
It
right,
may be
forget
wrong
142.
finding.
All right, no, forget 142. But NJSC, in 2 paragraphs, they say that this will result in a constitutional breakdown. Justice Keir says that they will, we were trying to see whether there will be a constitutional breakdown in a case like this. There wouldn't be, because no law then becomes invalid. It's just that the law has to be justified by the state. Being a reasonable
I
legislature.
wanted to read few more paragraphs, but if your lordships have, my lord, decided to not go into it, I wanted not, my lord, your lordships to persuade not to, for good reasons. But if your lordships, my lord, have decided, I have nothing more, lordship.
We have to look at it because NJSC doesn't, the logic of NJSC.
It's not referred, my lord. Therefore, my lord, I think advisedly not referred. Should we, my lord, expand the scope?
Because
Lord, would your lordships read para 70?
Do is this.
Only a minute,
What
only a
we
minute.
do is this. We have heard you now on this. We have told Mr. Andhyarujana, he has to argue the 31C point. Let's hear Mr. Andhyarujana.
That means our point is rejected, my lord. But before your lordship rejects our submission, look, 2085.
I'm not rejecting it. Hear Mr. Andhyarujana, we've heard you on that.
That amounts, well, and doesn't matter, it's entirely your lordship's jurisdiction.
Yesterday we prevented him from arguing it. Let us hear what he has to say, then we'll take a call.
Lord, 2085, my lord, would your lordships come?
At the end of it, we may still say that 31C, we need not go into it at all. We may still say it and say that, well, Vaman Rao says this, Minerva Mills says this, NJSC says this. Or if he persuades us to a contrary viewpoint, we may take a contrary view, but we'll have to hear him for that. Because
Lord,
yesterday
only a
we
minute,
heard
my
him.
lord. My lord, before that, would your lordships come to para 75 of Minerva Mills? My lord?
Yes.
It's 2085. And keep, my lord, section 4 in mind. Your lordships have read section
Now,
4.
Since we are on 75, why don't we reach 58 and then go to 75?
58.
The challenge. Let's go to para 58.
Of 58 will also apply.
Yes, ma'am. It's 2079. ma'am. It is in this light that the validity of the amended Article 31C has been examined. Article 13(2) says that states shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall be to the extent of contravention be void. Article 31C begins with a non-obstante clause by putting Article 13 out of harm's way. It provides for a certain consequences, notwithstanding anything contained in Article 13. If it that denudes Article 14 and 19 of their functional utility by providing that rights conferred by this article will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On the reasonable interpretation, there can be no doubt by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated at least in regard to the categories of laws described in Article 31C. The startling consequence which the amendment has produced is that even if a law is in total defiance of mandate of Article 13, read with 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the two charts of cases submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But then, in our opinion, is beside the point. A large majority of laws, the bulk of them can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of state towards securing some principle or other laid down in Part 4. In respect of such laws, which will cover an extensive gamut of relevant legislative activity, the protection of Article 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some of the laws will fall outside the scope. Now 75. We may have a serious issue with 31C. But someone will have to lay a challenge, my lord, not on the ground that it doesn't revive. And that challenge, my lord, will have to be, my lord, met with by us. There is no challenge, my lord.
It is struck down. So nobody can challenge it.
My lord, it is upheld by 13 judges as, my lord, in Keshwanand Bharti.
Reason, you
On-
see paragraph 58, the reason why it is struck down is
It's not struck.
shutting out an argument under Article 14 and Article 19
Lord,
on the
substitute.
basis of fundamental rights to a law is against the basic structure.
My lord, substitution is struck down. Section 4 of the amending act is struck down. 31C is upheld by 13 judges.
Talking in 1980, what happened? Once section 4, the amendment is struck down, what remains? The previous provision and the subsequent provision are in pari materia. In fact, the expansive provision is struck down, the limited provision goes with it.
My lord, I won't be able to go beyond saying that it is,
The
The-
same thing in para 61. See para 61 also.
Lord, I leave it to you, Lord.
Para 61 also see. Articles 14 and 19 do not confer fanciful rights. They confer rights which are elementary for the proper and effective functioning of a democracy. Then they say if Articles 14 and 19 are put out of operation in regard to the bulk of laws which the legislatures are empowered to pass, Article 32 will be drained of its lifeblood. Then they continue, then the power to take away the protection of Article 14 is the power to discriminate without a valid basis for classification. And then in the end they say, the nature and quality of the amendment introduced by Section 4 of the 42nd Amendment is therefore such that it virtually tears away the heart of basic fundamental freedoms. This is what they say in these two paragraphs.
No, may I have 5 minutes?
Then 362
No, I wanted to read, my lord, kindly note, my lord, few paragraphs. I will not read it, my lord, now that your lordship, my lord, seems to be convinced, my lord, on this. But para 75, my lord, for my satisfaction, for whatever
75.
this, my lord. 75, my lord, at page 2085.
Yes.
62 is also.
Then, these then are our reasons for the order which we passed on May 9, 1980 to the following effect. As my lords were saying, my lord, the operative part was pronounced first.
Here it says May 9th, May 9th.
Pardon?
Although it was passed in August 80, specifically say, these are for reasons the order were passed on May 9. It will be read as if it was passed.
Statement
on May.
later.
Yeah, the reasons came later. my lord. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution. Lord, please keep Section 4 on the side, my lord. Page 3966. Please keep it on the side. Volume 4. 3966, Volume 4. And what Minerva Mill does. my lord. Lord, I have that, my lord, 3966, Volume 4. Your lordships have that, my lord?
Yes.
I may read, my lord, for the benefit of everyone, my lord. In Article 31C of the Constitution, for the words, brackets, letters, and figures within comma, the principles specified in Clause B or Clause C of Article 39, the words and figure within inverted comma, all or any of the principles laid down in Part 4, comma over, shall be substituted. Correct, my lord? So now they say that every entire chapter protects any challenge. Now the court, my lord, in the para 75 says in Minerva Mills, Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. The substituted part, Section 55 of the amendment is beyond the amending power with which we are not concerned. So what is set aside is 4. And thereafter, my lord, Vaman Rao deals with this and says that the position prevailing before 42nd Amendment Act in 31C stands restored.
They don't say that in Vamanarao. They don't say that there is a revival. Vamanarao doesn't use the expression revival or restoration at all. Very careful. We saw Vamanarao. We'll give you.
My lord, would your lordships come to volume 2B, page 8? Volume 2B, page 8. Your lordships gets one?
Yes.
My lord justice. This is Vaman Rao. After Minerva Mills, after noting Minerva Mills, after noting that this bracketed portion is set aside or declared unconstitutional, holds this. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution 42nd Amendment Act, which I read, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharati. Article 31C, as it stood prior to the Constitution 42nd Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure.
But this is prior to the substitution. The issue of revival was never dealt with.
After the substitution, my lords. I may be, my contention may be wrong. Factually, I'm right.
Actually, it's not so, because it says that 31C, as it stood prior to its amendment in 1976, is valid to the extent to which its constitutionality was upheld in Keshwanand.
Keshwanand.
So it only tells us what is the decision in Keshwanand, namely that 31C prior to Keshwanand and as upheld in Keshwanand is valid. That's all.
Further,
It does not deal with what is the effect of the substitution having been struck down.
Would
That's
your
not
lordships-
here at all.
Lord, it deals with 42nd Amendment, my lords. Lord, 42nd Amendment.
We have to deal with it. Vaman Rao doesn't give us an answer. Vaman Rao doesn't give us an answer to the conundrum.
Probably will also
We have
look at
to-
it like this. This law stands on the same footing as paragraphs 413 of NJAC judgment. It stands on the same logic and the same footing. It doesn't have to expressly say so. The conclusion is well drawn from this. Otherwise, the theory of vacuum would probably equally apply to every situation when.
There's no vacuum here. That's the problem which you face.
There's a vacuum in the law.
There
It's
could
not
be a
about-
vacuum. Parliament wanted a protection.
There's no vacuum in the law.
Oh,
The vacuum in the, yes.
The law doesn't become, there would be a vacuum if the law.
Lord, my Lord, can I put it a little candidly? Can I put it?
The law still can benefit from the presumption that a law made to give effect to a directive principle is presumed to be reasonable.
Lord, can I put it a little candid? Can I put it a little candidly? 31C, as we read it, we find it difficult to accept the proposition that it is not even, it is immune from challenge. But, Lord, it will have to be challenged in an appropriate proceedings. This may not be, Lord, proper, Lord, procedure to declare 31C as non-existent.
The immunity, so they're entitled to say that the immunity doesn't apply. There's no question of challenging it.
There's no need to.
Once you set up the immunity, you
But,
can argue that the immunity does not
I will
apply.
still urge this, Your Lordship say that the vacuum principle is squarely upheld because what remains after 31C, second part gone, the first part gone,
Lord,
nothing remains.
It's
Therefore, there is a
difficult, my
vacuum.
Lord, to accept immunity,
There's a complete
but
vacuum.
not by not revival doctrine.
Deprivation of an immunity as a matter of constitutional concept is not a vacuum. Because the law is still presumed to be valid, the presumption of constitutionality.
IR
applies.
Polo takes care of that.
It is
Coelho takes care of
susceptible, that's all. It's only that it has to be justified.
If 31C had a
Lord,
legitimate place in the
Lord, may I-
constitution, it had a legitimate place in the constitution,
All right, I think
minus
what
what
we-
second amendment it would have
You've
had.
got your point. You've got your point. I mean, this is not a matter which is free from difficulty. Mr. Dwivedi, would you like to add? And then we'll call upon Mr. Andheri.
Yes, Lord.
My Lord, only, my Lord, before that,
The position prior to
only one.
What we'll do is, we'll hear Mr. Andheri because we have not heard him. We'll have to put our doubts now to him as well.
Just
Lord,
just
two
3 minutes,
paragraphs,
not
my Lord,
argue.
can I complete? Of NJSC.
Oh, sure.
And, my Lord, please avoid, my Lord, for the time being, don't keep, my Lord, that constitutional breakdown in mind. But it's not necessary. My proposition is that it is only when constitutional background is the result that revival does not take place, and in other provisions it take place. Either it takes place or it does not take place. That's, my Lord, that's a respectful submission.
if we go by your theory of revival.
Para 5.
Article
Wait,
5,
what?
if you go by the theory of revival, if Article 31C is now struck down, what revives is the position prior to Article 31C. That means the immunity goes.
Lord, if the honorable court believes it is struck down, Lord, I have nothing to say, but it is not. I don't think the other side says it is struck down. It is upheld in 13 judge judgment. It's not struck down. The amendment of 42nd amendment is struck down. But I leave it at that. Lord, I can't.
Which other paras, Mr.
Lord, 4106, volume 5.
106.
Para 989. Lord, this is a concurring view of Justice Joseph. Justice Kurian Joseph. The Lordship gets, my Lord. One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium. I'm sorry, my Lord Justice Padiwala gets, my Lord. One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium does not resurrect, according to me, does not appeal even to common sense. The 99th amendment sought to substitute a few provisions of the constitution and insert a few new provisions. Identical situation to 42nd amendment. Once the process of substitution and insertion by way of a constitutional amendment is itself held to be bad and impermissible, the pre-amended provisions automatically resurface and revive. That alone can be the reasonably inferential conclusion. Legal parlance and common parlance may be different, but there cannot be any legal sense of an issue which does not appeal to common sense. That you, instead of X, you substitute with Y. The court says that Y is not a valid substitution. Then X would revive, rightly or wrongly, this is what it says. And the last, Lord, page 4156. Lord, the same judgment, Justice Goyal's view, my Lord, para 1110. 1110, my Lord, page 4156. All the three honorable judges have, my Lord, dealt with this issue. May I read? I'm sorry, my Lord Justice Pandi. Only a minute, my Lord. My Lord Justice Pandi. Placitum H at the foot.
The foot.
May I read, my Lord Justice? Look, this is the view of my Lord Justice Goyal, my Lord. The contention that even if the amendment is held to be void, the pre-existing system cannot be restored has no logic. In exercise of power of judicial review, a provision can be declared void, in which case the legal position as it stands without such void provision can be held to prevail. It is not a situation when the position has not been made clear while deciding an issue. Power of this court to declare the effect of its order cannot be doubted, nor the decisions relied upon by the respondents show otherwise. I hold that on amendment being struck down, the pre-existing system stands revived. None of the honorable two judges do not mention about any breakdown. They, as a proposition of law, that you have substituted X by Y, Y is declared unconstitutional. Therefore, X revive. That's the word used. That's my. We'll elaborate, my lord, if needed.
Please bear in mind that the substitution happened by virtue of section 4. Section 4 enlarges. It's a substitution by enlargement. This court holds that this is against the doctrine of basic structure and therefore void. It's very important. Whole of section 4 is void.
Just a second.
There are numerous judgments.
Substitution of the original took place by
Section 4
enlargement.
by enlargement,
This one,
expansion.
by expansion. And second, you said section 4
Was declared null and void by exercising the doctrine of ultra vires on account of destruction of the basic feature of the Constitution. One, my lords, there are numerous judgments of this court without dissent that, including in the context of Article 13, that if a law is declared to be void, then it is void stillborn, void.
Any controversy on it, as to whether it is stillborn or it becomes void from the date of the declaration. That,
So,
just Matthew's judgment in Ambika.
so I would prefer to use void ab initio. Stillborn would mean, my lord, it never operated, but what happens is that generally there is a time lag between the making of the constitutional amendment and the declaration of ultra vires by the court. So in the interregnum,
Acts may have been taken
that
place.
some things may have been done. So whenever a lordship declares ultra vires, a question arises, what should be the form of declaration?
You say what happened.
Whether a lordship will protect or not protect. But one thing is certain, that the law, unless made prospective, operates retrospectively from the date the law came into operation. So unless your lordship gives it prospectivity, partial prospectivity, retrospectivity with protection,
The law was never enacted.
never enacted. So if section 4 is to be held to have never been enacted by virtue of this declaration in Minerva Mills, then the logical sequitur is that the section 31C, as upheld in Keshwanand Bharati, stands as part of the Constitution. There is no question of revival, resurrection. That's a misnomer, my lords. It stands. It was never substituted. Something which is void ab initio can never substitute. So sections 4 was dead or declared dead retrospectively. There is no prospectivity attached, my lord, in the declaration in the Minerva Mills.
Yeah, now we got the point. We'll hear Mr.
The other thing is, my lord, there's one more thing. Something absolutely inherent in the word substitution. Please have section 4 para 412.6 of the judgment which our lordships were reading. Page 3883. An earlier 3-judge judgment has been approvingly referred to in the context of what is substitution.
This is what? What are you referring to?
Page 3883. Yes, NJAC judgment, which our lordships were considering. Central Provinces Manganese Ore Company, this is three-judge judgment, which is relied upon for revival direction.
2016, volume 5, assist.
Yes. Paragraph.
1977.
Huh? No, not that. NJAC is Lordship. Reference was then made to Central Provinces Manganese Ore. We do not think that the word substitution necessarily or always connotes, I'm sorry, paragraph 412.6 at page 3883.
Why will?
The chart is slightly defective. It suggests as if that portion is struck down. It's the entire section 4 which is struck down.
It is created by, it's a confusion created by the chart. It's our confusion.
Okay, Shivananda Bhatt.
By us.
Chart.
By us. So just read this, para 412.6.
Judgment.
Kindly peruse this, 412.6. We do not think that the word substitution necessarily or always connotes two severable steps. That is to say, one of repeal and another of fresh enactment, even if it implies two steps. Indeed, the natural meaning of the word substitution is to indicate that the process cannot be split up into two pieces. Like this, if the process described as substitution fails, it is totally ineffective, so as to leave intact what was sought to be displaced. That seems to us to be the ordinary and natural meaning of the word shall be substituted. This part could not become effective without the assent of the Governor General. The state governor's assent was insufficient. It could not be inferred that what was intended was that in case the substitution failed or proved ineffective, some repeal not mentioned at all was brought about and remained effective so as to create what may be described as a vacuum in the state law. So maybe vacuum or not is not the question at all. Question is substitution is an amalgam. It repeals and replaces something. So it can't be that in part it is struck down, gone, but the repeal part remains. That's what this judgment said.
It was never there. It was never born because assent was not there.
No,
In this case, it came into effect, substitution was done, and then declaration.
no, the point is that once your lordship declares the substitution itself to be void. What are we reading? How do we read section 4 now? What are we reading? We are reading it as if section 4 have those struck down as void in Minerva, yet the substance of the amendment goes, the old doesn't revive, so it's a repeal. So the repealing effect is surviving. The repealing effect of section 4 is surviving. Therefore, notwithstanding the declaration that it is void. How can that happen, my lord? We are splitting up the declaration of the court in Minerva Mill. Part is void, part is surviving. Section 4 reads, this will be substituted. 4 is gone. So where is the substitution? So in a matter of substitution, it's an amalgam. The going out and the coming in are one intertwined act of the legislature. The whole goes. Unless the court splits it up, having found that it is severable, then of course the lordships can say that we are striking down this part of it, but we are not reviving. That the court never said. It declares the whole entirety of section 4 null and void. So it can't have a split effect. The third thing was, I'm not elaborating. I have numerous judgments which I can cite, but I'll do it when my turn comes. But the third and more important is, what is this doctrine of basic structure under 368? The doctrine is that if you damage the basic structure, then what you are doing, your act is beyond your competence under 368. So the amendment which brought about the enlargement is been held in Minerva Mill to be beyond the competence of the Parliament under 368. So what is beyond the competence, my lords, cannot have any effect at all. It can't be that it was beyond the competence, yet in part, in some little part, it is still surviving to have the repealing effect of what was upheld by 13 judges. And it has dangerous consequences, as the learned solicitor said, which your lordship, of course, will elaborate. What all can be amended, and then, my lords, every time this court will be, my lord, be troubled with this. How much of it is, my lord, reviving or not reviving? In my submission is quite contrary to Mr. Nariman's. He says, refers to that expression, stands part of the Constitution. That's what in Article 368 is, that once the bill is passed, it stands amended in terms of the bill. But he misses the expression which is earlier. Once it is passed and assented thereupon. Now, if it could not be passed, once it is void, it could not be passed, it could not be assented. So there is no question of the thereupon effect following. That is stands part. Merely because the ultra vires declaration comes, my lord, after a decade, it doesn't mean that it was the last 10 years competence. That's the thing.
Can I just take 2 minutes? I'll just
We'll now hear everybody later. Mr. Andarujana.
Lords, I'll just supplement 1 minute.
Two dates.
1 minute, 2 dates.
Get your full turn now. You get your full turn. There were 3 counsel on one self-evident proposition. Now, Mr. Andarujana.
Only 2 dates.
Let him argue.
2 dates.
In response, yes. Mr. Andarujana, please start now.
First of all, Lord, I want to express my gratitude to your lordships for taking up this point, Lord. But it is an important point, a point particularly important for the facts of this case. Lord, I fully understand the concerns expressed by my learned friends, Lord, the Solicitor General, the Attorney General, Mr. Dwivedi. But regretfully, my Lord, I disagree with almost every statement of law that they have made. Lord, Mr. Nariman's point, my Lord, in my respectful submission, is a point which carries great force and a point which requires a determination by your lordship's bench. Now, my Lord, I have divided my arguments, my Lord, into 4 segments. But I'd just like your lordship broadly to know how I wish to address your lordships today. Lord, I will just frame the issue before your lordship precisely because I think, Lord, it is important that we understand that we are dealing with the effect of a declaration of unconstitutionality on a substituted provision in the Constitution. And that is the precise issue. But I'll just frame it in a moment for your lordship.
Just
and I will say,
effect of the declaration of a substitution, declaration of unconstitutionality.
yes, Lord.
Just one second.
Yes, Lord.
Effect of the declaration of unconstitutionality on a substituted provision
In the Constitution. And my Lord, and I think it is important, my Lord, that we bear in mind the distinction of this issue from other legislative activities such as repeal and introducing the laws. My lord, it's an important distinction to be borne in my respectful submission. My lord, I hope that I will persuade your lordship, sir, that is the case. My lord, I will, so my lord, the first part, my lord, I wanted to address your lordship on, my lord, which will nail, my lord, to the mast, my lord, with some certainty. My lord, what exactly factually took place? My lord, so much will become evident from that, because I will show your lordship that for 20 years, in fact, for about 22 years, my lord, there was no Article 31C did not exist in the Constitution at all. It came in later. My lord, I'll also tell your lordship, my lord, in a nutshell, my lord, about the reasons for introduction of Article 31C. My lord, there is no constitutional chaos which is going to result, as your lordship alluded to, for different reasons. But I also want to set out, my lord, how the Minerva Mills judgment came to be. And I want to point out to your lordship that actually the problem is a problem post Minerva Mills. So it is a problem post 1980. So not if we bear that in mind. But the issue that we have is a post 1980 issue. But that will all become evident, my lord, in my legislative history. But the third issue which I want to address your lordships on, so the first was to frame the issue correctly. Well, the second, my lord, was to deal with legislative history very swiftly, my lord. I won't take your lordship's time on that. And my lord, the third, my lord, I wanted to deal with the effect of Lord Minerva Mills, Vaman Rao, and the successor judgments. My lord, there are in particular two, my lord, Sanjeev Coke Mills, Sanjeev Coke, and the other one is the Bhim Singh Ji judgment. My lord, and also, my lord, there's another judgment called Basanti, my lord, which actually dealt with a 31C challenge to MHADA itself, where also, my lord, 31C was noticed and the learned judges proceeded on the basis that in fact it was valid. So, Lord, I'm going to show your lordships all of those. Lord, I hope to immediately and swiftly show your lordship that Minerva Mills clearly proceeded on a concession which was made by Mr. Palkhiwala, Lord, who was arguing the case. But the issue in fact never arose in Vaman Rao, which will also become evident from the dates in my legislative history. It could not have arisen because the question of striking down was not before the court in Vaman Rao at all, for that simple reason. But, Lord, I hope to elaborate on that. Now, my lord, I also, my lord, in the next segment of my arguments, my lord, want to deal with the NJAC judgment because, my lord, it is, I did find it, my lord, curious that my learned friends relied upon it because that judgment, my lord, was a judgment I wanted to rely upon. But it entirely, in my respectful submission, my lord, supports my arguments, as I will show your lordship. My lord, and it distinguishes, of course, that amendment as saying that that amendment was not a substitution. Now, that really, my lord, is the short point with regard to the NJAC judgment. I hope to make that good. And it otherwise, my lord, fully accepts, my lord, the submission that in fact there is no doctrine of automatic revival. My lord, the last part of my address, my lord, is on the consequential aspects in the event that I am to succeed. My lord, there will be no, my lord, constitutional chaos. There will be no crisis, as I will show your lordship. And to your lordship's very pointed question about whether this is purely a technical point, in the sense that Parliament can always step in and take the necessary steps to redress it, my lord, I'll make a few comments on that. So, my lord, that is how I propose to go about this. My lord, my time estimate, my lord, is approximately 2 to 2.5 hours, if your lordship will permit me that. My lord, so, my lord, I will straight away start. My lord, by, if your lordships don't mind, my lord, I have prepared a note on this. My lord, I have prepared a note on this. My lord, the note is actually what I gave your lordship yesterday and the same note from which I argued the Coelho point. My lord, today, my lord, I will be relying on serial numbers 1 and 3. My lord, the note has an index in front, if your lordship will see it. My lord, it has 3 items, but Roman 1 is legislative history and Roman 3 is whether 31C is a dead letter. But my lord, before I go to the note, my lord, I wanted to, my lord, give your lordship, my lord, a brief overview of the legislative history. My lord, it is not even necessary to read this note. My lord, I think I can effectively bring it out in a few minutes before your lordships. Do your lordships have the note, just so that...
It's one.
Where is your note?
My lord, it's 1B in the Google Drive, 1B.
Volume 1B.
Look. Name is note tendered by Mr. Zalti and the original senior advocate.
Got a lot of...
Legislative history of Article 31C.
Yes, no, my lord, it says, yes, legislative history of 31C of the Constitution is the first item, relevant to the present case. It's not a general history, my lord, relevant to the present. If all of your lordships have it,
Just 1 second.
yes, please.
I have one, which is garbled, the garbled version. Let me see if
Please.
start. Okay. Not in community. Yes.
Lord, so Lord, it is a longish note. So Lord, I'll just summarize it first to your lordships. Lord. Lord, just your lordships will kindly mark one date, my lord. That is item 5 of my list of dates. Lord, that is 20th April 1972. And that is the date of insertion of Article 31C.
What are you reading? Which page?
Lord, it's page 6, PDF page 6. So, Lord, your lordship will just note that date. Now, Lord, I first wanted to address your lordship on some constitutional events prior to that. Lord, on 18 June 1951, we have the First Amendment. Lord, just orally, Lord, just a few minutes. Lord, the First Amendment, Lord, introduces Article 31A and Article 31B. Lord, the speeches piloting it through Parliament, Lord, which are given by Pandit Nehru, Lord, all indicate that it is really for the purpose of agrarian reform. Lord, which was one of the important platforms, Lord, of the Congress Party back then. Lord, it is immediately challenged, Lord, in Sankari Prasad's case in 1951. Lord, Sankari Prasad's case, the challenge is whether 31A and the amending law of the Constitution amounts to law under Article 30. Lord, and the question is therefore, if constitutional law is law as understood under Article 13, Lord, if it is law as understood under Article 13, then the effect of that on Part 3 what was to be considered. Lord, Sankari Prasad rejects that challenge. But several years later, in Sajan Singh's case in 1965, Lord Sankari Prasad's view is upheld. Lord, in 1967, Lord, we have Golaknath's case. As your lordships know, Lord, Golaknath resulted in a 6-5 majority. Lord, and the effect of the 6-5 majority was to hold that Section 368 is not the source of the amending power of Parliament. It is a general power that the Parliament has. And that Article 13A, constitutional law, is the law which my apologies, Lord, that the law under Article 13A is constitutional law, namely the law which is used to amend the Constitution from time to time. Now, Lord, as a result of Golaknath's judgment, your lordship knows that Golaknath then set out the principle of prospective overruling, which was till then, Lord, actually a concept which was alien to our jurisprudence. But, my lord, as a result of this, my lord, there was a severe limitation, my lord, which was then placed on the constituent power of Parliament. But Parliament reacted, my lord, by introducing 2 amendments. My lord, the first amendment was on 5th November 1971, which was the 24th Amendment. My lord, they made certain amendments to Article 13 and in Article 13(4). My lord, and they made significant amendments then to Article 361 and to the marginal note, effectively making it clear that Parliament had an unlimited power to amend. My lord, on 20th April 72, then they introduced the 25th Amendment, that is Article 31C. Now, my lord, my point, my lord, my limited point, but thus far is this. My lord, that from inception, my lord, Article 31C did not exist. Article 31C came about as a parliamentary reaction to the judgment of the Supreme Court in Golaknath's case. So, my lord, it was to some extent, my lord, in the parliament, the tension between parliament and the court manifested itself in the 25th Amendment, namely on 20th April 1972. So, my lord, from the date of inception to the Constitution till 72, my lord, chaos did not reign. My lord, there was no anarchy in the country. My lord, the constitutional provisions remained as they were. And my lord, if I am right, my lord, we will revert to that position, my lord, prior to 1972. Now, my lord, Keshav Nanda's judgment, my lord, comes immediately, shortly thereafter, because, my lord, in fact, my lord, the 25th Amendment is immediately challenged, as your lordship knows, one of the aspects which is challenged in Keshav Nanda's judgment. And, my lord, we have the judgment then on 20th April 1973. My lord, Keshav Nanda's judgment notices the basic structure, my lord, which is then further commented upon in Indira Gandhi's case. Now, my lord, we have the 42nd Amendment, which comes on 18th December 1976. Now, my lord, the 42nd Amendment, my lord, has the effect of expanding Article 31C. And your lordship will find this, my lord, in my list of dates, if your lordship will kindly look at PDF page 12. I'll just read to your lordship, so your lordship has in an orderly manner, my lord, what the amendment did. Your lordships, all of your lordships have that. But it's item 8, page 12.
PDF page 12.
Yes, Lord. PDF page 12. Item 8.
And there we have that section 4, which we read from Minerva Mills.
Yes. But I quickly just breeze through it to give your lordship a comprehensive view. The Constitution 42nd Amendment Act, inter alia amending Article 31C, received the assent of the President of India. The amendments were as follows. Insertion of new subheading after Article 31. After Article 31 of the Constitution, the following subheading shall be inserted, saving of certain laws. 4. The amendment of Article 31C. In Article 31C of the Constitution, for the words, brackets, letters and figures, the principles specified in Clause B or Clause C of Article 39, the words and figures, all or any of the principles laid down in Part 4 shall be substituted. But there was also then an amendment which was made to 368, Lord, which is not really relevant, but for the sake of completeness, my lord, I have set it out to your lordship. Now, my lord, if your lordship will then go down to item 9, my lord, how did it stand as a result of the amendment? I've set it out there. My lord, the amended, this is at PDF page 13. The amended Article 31C read as under, saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any rights conferred by Article 14, 19 or 31, no law containing a declaration that it is for giving effect, my lord, so on and so forth. But as we know, my lord, part of it, my lord, was then subsequently set aside. Now, my lord, if your lordship will just go to item 10 and kindly note the date also. My lord, in 1977, the writ petitions were filed under Article 32 in the Honorable Supreme Court in Minerva Mills and Union of India, inter alia challenging the constitutional validity of Section 4 and Section 5 of the Constitution 42nd Amendment Act 1976. The writ petitions under Article 32 filed in the Honorable Supreme Court in Vaman Rao versus Union of India, inter alia challenging the constitutional validities of 31A, 31B and unamended Article 31C. So, my lord, these two matters, my lord, have historically always moved in step and moved together. Now, my lord, a very interesting development takes place immediately thereafter, which I want to bring to your lordship's notice. My lord. On 15th May 1978, the Constitution 45th Amendment Bill, so my lord, this is the bill of 1978, which is Bill 88 of 78, to further amend the Constitution of India was introduced in the Lok Sabha. Clause 8 of the bill read as follows. So, my lord, this was an attempt by Parliament. My lord, the government had now changed, and it was an attempt by Parliament to actually once again narrow the effect of Article 31C, as your lordship will see. So, my lord, the amendment, my lord, and my lord, 8 of the amendment read thus.
They wanted to restore the position as it was prior to the 42nd Amendment.
Exactly. My lord, they wanted to restore the position as it was prior. My lord, and as I will show your lordship, my lord, from this, actually, my lord, the bill, my lord, of course, my lord, passed as an act, but without this portion being passed by the Rajya Sabha. So, my lord, if your lordship will just permit me to read this through, my lord, that will become evident to your lordship. My lord, for the words, figures, all or any of the principles laid down in part 4, the words, brackets, letters and figures, the principles laid down in clause B or clause C of Article 39 should be substituted. So that is what they wanted to bring back. For the words and figures 14, 19 and 31, the words and figures Article 14 and 19 shall be substituted. Now the second part was successful. Lord, 31 stood deleted. The first part was not. The words and no law containing a declaration that is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy shall be omitted. Now, Lord, that was the portion. But that was the portion which had been dealt with by Keshav Nanda.
Proposed bill which never passed the Rajya Sabha. So 31, 19(1)(f) was deleted, 31 was deleted, but this remained as it is.
Exactly, this remained as it is. And not of note, my lord, is the deletion also. My lord, when and why, my lord, it.
Omission of what?
My lord, if I may just read the notes. Sorry, if I just read the note to that, my lord. The notes on clause to clause 8 read as follows. The amendment proposed in subclause A or this clause is for confining the protection afforded to Article 31C only to the laws giving effect to the policy of state towards securing the directive principles specified in clauses B and C of Article 39. This would have the effect of restoring the article to the form in which it stood before the amendment made to the article by the Constitution 42nd Amendment Act 1976 came into force. The amendment proposed in subclause B is consequential to the omission of Article 31 above. The amendment proposed in subclause C is for omitting the portion related to the declaration contained in Article 31C, which was struck down by the Supreme Court in Keshav Nanda Bharati. Now, Lord, that is a point which I want to develop a little later on. What is the effect of a declaration of unconstitutionality on a constitutional provision? Lord, it is now, I respectfully submit, an accepted position that it does not get excised from the statute book. It remains in the statute book and it actually has to be removed by Parliament. And Lord, of course, the relevance of this point is that the pronouncement by the courts on the constitutionality of the articles of the Constitution, in my respectful submission, invariably require a consequential parliamentary action. So that's a point that I hope to develop for your lordship, Lord, as we go along. Lord, the bill also sought for a deletion of Article 19(1)(f) and Article 31 and the insertion of Article 300A. Now, about the fate of that bill, what exactly happened to it is at item 12. The Constitution Bill was considered by the Rajya Sabha. During the consideration of the 45th Amendment Bill by the Rajya Sabha on 31st August 1978, the motion for retaining Clause 8 as a part of the bill was put to vote. The motion was not carried by a majority of the total membership of the House and by a majority of not less than 2/3 of the members present and voting. Note, the proposed amendment of 31C in terms of Clause 8A of the Constitution Bill was thus omitted from the bill by the Rajya Sabha. Thereafter, a consequential amendment to 31C was moved under Clause 7A. Lord, I'll just read it, Lord. Shri Shanti Bhushan, may I have your permission to move a consequential amendment? Now that Article 31 has been deleted by the adoption of Clause 6, reference to Article 31 in Article 31C is inappropriate. Therefore, I'm moving Amendment 103 that the page after line 4, the following new clause be inserted, namely in Article 31C in the Constitution for the words and figures Article 14, 19 and 31, the words and figures Article 14 and 19 shall be substituted. So Lord, that is how, Lord, Article 31 came to be deleted from Lord, I'm sorry, but that is how, Lord, the mention of Article 31 came to be deleted from Article 31C. But Clause 7A was thereafter put to vote. The motion was carried by a majority of total membership of the House and a majority of not less than 2/3 of the members present and voting. Now, Lord, as a result of this, what did Article 31C look like? I put that out in 13.
Yes, Mr. Andarjan.
Please, Lord. Lord, the result, Lord, what Article 31C now look like, Lord, as a result of this legislative process, Lord, I've set out at item 13 of my list of dates, page 70. Lord, the saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent or takes away or abridges any of the rights conferred by 14 and 19. So 31 stood. Now, Lord, now we come to Minerva. Lord, if your Lordship will turn to page 18 of my list of dates. Lord, on 9th May 1980, Lord, we have the order in Minerva Mills case. Lord, the Chief Justice, Justice Chandrachud, P.N. Bhagwati, A.C. Gupta, N.L. Undwalia, and P.S. Kailasam. Lord, 5 judges. Inter alia holding, or this is of course the majority view, that Section 4 and Section 55 of the Constitution 42nd Amendment Act to be void on the ground that it destroyed the basic structure of the Constitution. Now, Lord, I've only extracted here, not some part of the order. But Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of Parliament and is void since it damages the basic or the essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19 of the Constitution, if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 of the Constitution. And as far as 55, just for 55, just for the sake of completeness, Section 55 of the Constitution is beyond the amending power of Parliament and is void since it removes all limitations on the power of Parliament to amend the Constitution and confers power upon it to amend the Constitution so as to damage or destroy its basic or essential features or its basic structure. So what Section 55 was that section that brought about amendments to 368, not giving Parliament plenary powers to amend. Note, well, the reasons for the decision were given in the judgment on 31/7/1980. Your Lordship said August. Your Lordship is not entirely wrong, but 31st of July 1980. See Minerva bills given below. Lord, there is a typo I noticed in one of the other judgments which refers to May. It is actually delivered on 31st July 1980. I think Justice Bhagwati's judgment states the date incorrectly.
Actually, right. 31st July 80 was post the vacation probably.
Yes, yes. The day Abhinav was born.
Now, my Lord, Vaman, sorry. So, my Lord, then, my Lord, I just referred to the judgment and the reasons coming later. But on the very same day, we have the judgment in.
This is something which we'll have to bear in mind, that though Minerva strikes down the entirety of Section 4 of the 42nd Amendment, by virtue of which all or any of the principles in Part 4 is struck down, Vaman Rao, for which the reasons are delivered later, Vaman Rao upholds 31C to the extent to which it was upheld in Keshwanand.
Unamended.
That is the unamended Section 30, Article 31C.
Because amendment was challenged there.
Right.
Not the amendment was not a
The
subsequent.
amendment of Vaman Rao.
And Vaman Rao is subsequent in time.
No, what was challenged in Vaman Rao was the unamended.
Yes, the original because it came from High Court.
By then, Keshwanand had been delivered.
Yes.
So they say that.
No, interestingly, that's what because if we see Minerva came in July, Vaman Rao came in November, in spite of noting that it has been set aside in Keshavanand. After that, a separate finding has been given, independent finding to say that unamended is declared unconstitutional.
Correct. What is the basis of that?
No, the interesting that
Unamended is the challenge.
that has been equated with 31A principle, Manas. To say the 31A, independent of Keshavanand, the independent 31A principle applied, and interestingly, by that time, Minerva was in hand. We had a judgment on that day.
Yes, Mr.
Both the cases.
Please, Lord, I am obliged to my learned friend, Lord, and he is undoubtedly correct in that, Lord, that the Vaman Rao rationale for upholding the unamended 31C was on an equivalence with 31A, which is what I will point out. But Lord, the point of relevance, Lord, for the present argument is that this question with regard to the unconstitutionality of a substituted provision was never present before the judges in Vaman Rao's case. For the simple reason that when the hearing stood concluded, the result of Minerva Mills was not. So, my Lord, the judgment could really never tackle this issue. But I'll come to the second point about what is the effect of, Lord, that declaratory statement which is made in Vaman Rao. But this issue which we are dealing with, but precisely this issue was not present in Vaman Rao's case either. Not for this reason, or for this coincidence of time. So, Lord, we then have I'll just finish this in a few minutes, Lord, we're coming to the end, Lord. On 9th May 1980, Lord, item 15, Lord, we have the Vaman Rao order, Lord, and here we have Chief Justice Chandrachud, Lord Justice Bhagwati, Justices Krishna Iyer, Tulsapurkar, and AP Sen. Lord, it's reported in 1983 SCC, 5 judges upholding the validity of unamended Article 31C to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C of the Constitution, as it stood prior to...
My learned brother Justice Roy is saying something.
No, I'm just going to say that instead of saying Chief Justice Chandrachud, you can say Chief Justice Chandrachud 1.
Lord, that
Yeah.
present, I will take your lordship's advice on that. Lord,
We can.
perhaps as the former Chief Justice Chandrachud.
Equally a senior.
Lord, it is a problem which doesn't come to council very often, my Lord. It is a problem which my Lord, so my Lord, the judgment in Vaman Rao is delivered. My Lord, and the extract is there, my Lord. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution, 42nd Amendment Act 1976, is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C, as it stood prior to the Constitution Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure. The effect of the substitution of the words all or any of the principles laid down in Part 4 for the words principles specified in Clause B or C of Article 39, effected by the 42nd Amendment, was not at all considered. Now, Lord, thereafter we have the judgment in Minerva Mills on 31st July 1980. Lord, the judgment is far too important to try to summarize. My Lord, I will take your lordship to the relevant passages, but for your lordship's convenience, my Lord, I have tried to summarize it, Lord, by referring to various passages at page 20. Now, my Lord, I will not deal with the note here, my Lord, because I'll make my submissions on Minerva Mills case, Lord, separately. Lord, I just want to point out to your lordship in conclusion of my list of dates, 2 or 3 more dates. On 13th November 1980, we have the judgment in Vaman Rao. Lord, once again, my Lord, it is a matter of great moment to this argument. My Lord, I will read from the judgment itself, if your lordships don't mind. And, my Lord, then we have 2 or 3 other interesting developments. Lord, on item 18, so Lord, once again in 1980, we have 3 very, very important judgments, all dealing with Article 31C. We have the third of those judgments, my Lord, which is on 13th November 1980, the order passed in Bhim Singh Ji's case. Now, Bhim Singh Ji's case.
Remember comes Bhim Singh Ji.
Yes, Bhim Singh Ji. Now, Lord, Bhim Singh Ji's case was the case which was referred to by my lady yesterday, Lord, in the context of the urban land sealing challenge. As my lady knows, Lord, in Bhim Singh Ji's case, the result of the majority was to strike down only one section, which was 27(1). But Lord, the effect of Bhim Singh Ji, Lord, is a very neutral effect on this argument, Lord, for reasons that I'll come to when I deal with the judgment individually. Now, Lord, your lordship will only note, Lord, relevant to the facts of this case. Item 19, on 26 February 1986, Chapter 8A of Madar is now introduced. So, Lord, just to contextualize it, Lord, to the facts of our case, Lord, this happens there. And, my Lord, sorry, my Lord, I seem to have omitted to mention to your lordship one relevant date, my Lord. Item 16, I'm afraid I failed to read that, my Lord. Lord, if your lordship will see the note, Lord, the judgment in Minerva Mills also referred to Sanjeev Coke. Lord, note 2.
Book referred to Minerva Mills.
Yes, Lord.
The reverse.
Yeah, the judgment in Minerva Mills was referred to in Sanjeev Coke.
I'm so sorry. So Sanjeev Coke is the other judgment which also deals with this 31C. My apologies, Lord.
Right.
I misspoke. My sorry. So, Lord, we have Sanjeev Coke, then we have Bhim Singh Ji's case. We then have the insertion, Lord, and then, Lord, if your lordship will just kindly turn to where's the order in Basanti? Just there is one more date which I want your lordship to have. I'll just give it to your lordship presently, my Lord. The order in
Basanti.
yes, my Lord, that is 1986. The exact date.
86 to
13th March 1986. 13th March 1986.
Right.
Then we have finally, my Lord, to conclude this, the order of reference from 3 judges to 5 judges on this issue.
That we have seen.
On 1st May 1996. My Lord, that is how the issue now arises before your lordship.
Right.
But may I now show your lordship, Lord, the Minerva Mills case?
Yes.
And then I will like to show your lordship Vaman Rao, Lord, before we move further. Lord, so if your lordship doesn't mind, Lord, Minerva Mills. Lord, your lordship will find that at page 2050 of the precedence compilation which your lordships have. But we are principally concerned here, my lord, with the majority view. But my lord, Justice Bhagwati actually, my lord, does something quite unusual. My lord, Minerva Mills, he also deals with Vaman Rao. So, my lord, may I refer your lordship first in Minerva Mills, my lord, straight away, my lord, to the question for consideration. And that your lordship will find at page 639. Sorry, internal 639, which is 2064. Your lordships have that, my lord.
So, and that, you know,
Yes, my lord. So, my lord, in the first paragraph, my lord, the question is summarized, my lord. My lord, in Keshavananda Bharati, this court held by a majority that though by Article 368 Parliament is given the power to amend the Constitution, that power cannot be exercised so as to damage the basic features of the Constitution or as to destroy its basic features. The question for consideration in this group of petitions under Article 32 is whether Section 4 and 55 transgress the limitation on the amending power. Then, if your lordship will kindly notice in paragraph 5, what a curious feature of this case was that the statute in question was actually a pre-amendment statute, as your lordship will see. By these petitions, the petitioners challenged the constitutional validity of certain provisions of the Sikh Textile Undertaking Nationalization Act and the